The courtroom held its breath the way it always did, waiting for the gavel of attention that was Judge Judy's voice. Case number 443, Aristo versus Morales. Two men, sworn in, ready to tell two different stories about the same 15 minutes of their lives. Orlando Aristo ran an auto shop, the kind of place where a man could limp in with a dying transmission and limp back out, hopefully, with a fixed one. On a November afternoon, a young man named James Morales had wandered in. No appointment, just a tip from a friend who happened to be Aristo's own nephew, and a promise of a fair price. Morales already knew what ailed his car. He'd paid for a diagnostic the day before at another shop, and the verdict had been grim. The transmission needed rebuilding. When Aristo finally arrived, 45 minutes late, he sized up the situation, took the car for a short spin up to the garage door and back, popped the hood, and declared that yes, the transmission needed work. Morales sat across from him, filled out paperwork, and the two men seemed for a moment to have reached an understanding. Morales left to consult with his wife. It was she, practical, watching the family's money, who changed the plan. They had just paid for one diagnostic. Why pay for another? When Morales returned to collect his car, something had shifted in the room. Aristo, now insisting his name was Giovanni, a name borrowed from the sign above his shop, told Morales he couldn't simply walk away. There was a bill, $85 for the diagnostic work. Work that, by every account except Aristo's own, no one could actually prove had happened. No wires, no tools, no mechanic crouched beside the car. The vehicle hadn't even been lifted. Morales refused to pay. The argument rose in volume, and then, as Morales tried to back his car out through the gate, an employee moved to close it. The vehicle didn't stop. It clipped the gate, struck a dumpster, dragged it into the side panel, and snapped off both mirrors before it broke free onto the street, leaving behind a scraped fender, yellow fence paint streaked across the door, and a furious shop owner shouting for someone to call the police. A witness for the defense, a customer with grease-stained hands who insisted, unconvincingly, that he didn't work there, described Morales fleeing like he was stealing the car. Frightened, the gate barely open a car's width when he ploughed through it. The judge listened to it all with the patience of someone counting down to a point she already knew she'd reach. She zeroed in on the gap in Aristo's story. If work had truly been done, where was the evidence? No employee came forward to say they'd touched the car. No invoice existed from the moment of the encounter. Only one written up afterward, full of details added in hindsight. And when she asked Aristo directly how he'd stopped Morales from leaving, as his own complaint alleged, he insisted he hadn't tried to stop him at all, a claim that contradicted his own paperwork. The timeline told its own quiet story. The Morales family filed their police report the very day of the incident. Aristo did not file his until the next day, claiming officers turned him away, a claim the judge dismantled in seconds, noting that if his version were true, the police would have logically told the Morales family the same thing, and they hadn't been turned away at all. In the end, the verdict was unambiguous. Aristo had no right to trap a customer who wanted to leave. He'd had every option to simply let the man and his wife go and pursue payment through the courts if he believed he was owed something. Instead, he chose confrontation, and confrontation had consequences. Judgment for the defendants, $1,700, enough, the judge noted dryly, to either fix the car or be forced to total it. Case 457, Jimenez versus Brooks. A love story already curdled into a courtroom drama, complete with a damaged car, a shattered cell phone, and a man who simply did not own a shower curtain. Amy Jimenez and Ronnie Brooks had been together a matter of months, 3 at most, when things fell apart in the front yard of her own house. The trouble, as it so often does, began with something small. Brooks didn't have a shower curtain at his own place, hadn't for 2 months, just took baths instead, and it was this domestic deficiency that brought him to Jimenez's house that October evening. They'd barely arrived when an argument erupted in the car. Jimenez didn't want to go inside. She wanted to drive him home instead. What happened next depended entirely on whose account you believed. Jimenez said Brooks went into her house and assaulted her roommate over some perceived insult, then came back out and threw her to the ground, kicking her in the leg. Shaken, she retreated to her car. Brooks, by his own admission, kicked the car twice, once on the hood, once on the side panel, though he insisted she'd been backing toward him as if to run him down, and that he'd kicked in self-defense for the vehicle, if not for himself. There was also the matter of the cell phone, which Brooks didn't dispute breaking at all. He'd thrown it across a parking lot during a separate flare-up the night Jimenez tried to leave with his clothes still locked in her car. The judge's skepticism deepened when she examined the timeline. The photographs Jimenez brought as evidence of the dented car had been taken nearly 3 months after the supposed incident. Taken by her father, she explained, because she hadn't owned a camera at the time. 3 months is a long time to wait if you are, as she claimed, terrified of the man who damaged your property. And the judge noted, pointedly, that fear doesn't typically lead someone back to a man's house 2 or 3 weeks later, which Jimenez admitted she had done, hoping to get her car repaired. There was also the small, damning detail of the witness, a friend named Derek, who'd been playing video games on the night in question, who confirmed seeing Jimenez's car lurch backward and then forward, as though aimed at Brooks, just before the single kick landed. The judge believed pieces of both stories, that Brooks had kicked the car and that Jimenez had been drunk and reckless that night. What he owed, ultimately, came down to a number: $400 for the dented panel, $80 for the phone. $480 total, with judgment for the plaintiff. But the judge reserved her sharpest words for what came after the math, a stern warning to both of them that driving drunk, which they each admitted doing regularly, was no longer a private bad habit, but a potential tragedy waiting to happen. If either of them ever killed someone behind the wheel, she told them, it would not be an accident. It would be a choice they'd been warned about. Larry Lane believed, with the conviction of a man who had learned his lesson the hard way, that his former tenant and her family were professional squatters, people who moved from rental to rental, paying just long enough to get comfortable, then stopping, daring the landlord to spend 6 months or a year evicting them. Kay Thomas, the woman in question, had moved into Lane's 3-bedroom home with a pool in February, signing a year's lease at $1,250 a month with her husband, and eventually her brother and sister-in-law as well, though Lane insisted he'd never agreed to the extra tenants. The first check bounced. Eventually March's rent was paid and April's too. But May, June and July came and went with no payment at all, even as the family continued living in the house through the end of July. Thomas's defense was a moving target, and the judge noticed immediately. First, she claimed they'd stopped paying because they were moving out, a story that might have held together if she hadn't also claimed her husband's job transfer fell through, and they'd stayed because their new house wasn't ready. The two excuses cancelled each other out, and the judge said so without mercy. You can't claim you didn't pay because you moved and also claim you didn't move in the same breath. Worse, in her own written answer to the complaint, sworn and signed, Thomas had never once acknowledged owing rent for those months. Under questioning, she finally admitted what the paperwork should have already said. 2 months of unpaid rent, $2,500 in total. Then came the matter of the furniture. There had been an arrangement. Thomas could purchase select furniture from the home, a dining set, a bedroom set, by paying it off over the lease term. She never finished paying. She sold it anyway, for $1,250, money that never found its way back to Lane. She admitted doing it out of anger after Lane allegedly tried to have her electricity shut off, a claim the judge dismantled with a subpoena from the power company, showing the cut-off was the result of Thomas's own bounced checks and a false social security number, not anything Lane had done. There was a refrigerator too, sitting in the garage along with a lawnmower and a power edger, all of which had vanished entirely. Thomas claimed a junk hauler had taken the broken refrigerator off her hands, conveniently, in the same month she moved out. The judge wasn't interested in convenient timing, and when Lane went back to inspect the garage, Thomas had him arrested for battery, a charge that never stuck. A quick background check painted the picture Lane had suspected from the start. A history of eviction, 6 bad checks, an ongoing diversion program for first-time offenders, though the judge noted dryly that being a first-time offender might simply mean it was the first time Thomas had been caught. The math, once the judge laid it out piece by piece, was inescapable. 2 months' rent, the unpaid furniture balance, legal fees, damaged blinds and screens. Judgment for the plaintiff, $5,000. Deborah Lomar ran a small home daycare, the kind of operation built on trust and informal arrangements, $4 an hour, or $20 a day, for children who came and went as drop-ins. Lisa Voltz's daughter had been one of those children until August, when Lomar terminated services over an unpaid balance that had crept up to $280. What followed, in Lomar's telling, was not just a financial dispute, but a campaign of harassment. The police had been called to her home 3 separate times. Once over a smoke machine, a harmless toy her husband used to entertain the daycare children, which a neighbouring parent mistook for a house fire and reported, only to laugh it off once she realised her error, an explanation the judge accepted without much patience for the theatrics that followed it. Twice more over allegations of profanity used in front of children, allegations that state licensing investigators ultimately found unfounded or inconclusive. Voltz, for her part, had her own grievance. She alleged that Lomar had told her 10-year-old daughter that Voltz was an unfit mother and that her other child was lucky to have escaped the household. She'd also accused Lomar of standing outside, shouting and cursing in front of the neighbourhood children. The judge, working through both timelines with the precision of someone assembling a jigsaw puzzle, found the thread that mattered. A money order Voltz had sent in October, accompanied by a letter explicitly framed as repayment of a debt. That letter, written well after the alleged slander against her daughter was supposed to have occurred, was itself an admission. If Voltz truly believed she owed nothing, why was she making structured payments and calling them debt repayment? The judge's ruling left little room for sympathy on either side. Neither the harassment claim nor the counterclaim about bad-mouthing held up as legally actionable on their own. Both women, she suggested, had likely behaved poorly toward each other, trading insults and behavior unbecoming of grown adults. But all of it traced back to one unpaid bill that should simply have been paid. Judgment for the plaintiff, $250. The counterclaim, dismissed. Shawana Balkan, 22 and freshly graduated, had moved from New York to live with her father in Savannah after he remarried. Grateful for the fresh start, she'd loaned him her credit card to help him catch up on bills that had piled up after the wedding. What began as a kindness curdled into a $5,000 lawsuit, built on a foundation of charges Balkan said she never made. Cash advances, mysterious deposits, a charge at a nail salon that she insisted belonged to her father's new wife. Her father told a starkly different story. He claimed he'd never even held the card in his hand, that the only charge connected to him was a wedding dress, already paid back. The confusion deepened when it became clear the wedding dress charge wasn't even on the card in question, a detail that left both father and judge briefly baffled about what exactly the lawsuit was supposed to be about. But baffled or not, the judge arrived quickly at the central, unavoidable problem. This was a case built entirely on dueling memories with no paper trail to settle it. Without signed receipts, the kind any credit card company could, in theory, produce, there was no way to determine who had actually authorized each charge. Balkan admitted she'd left Savannah with nothing but her clothes, leaving every receipt behind in her father's possession, receipts neither of them had bothered to bring to court. Faced with an evidentiary void neither side could fill, the judge declined to guess. The case was dismissed, without prejudice, a door left open, should Balkan ever gather the actual paperwork from the credit card company and return to try again. Mike Lewis had met Mary Goodman over the internet, moved to her city for a job, and somewhere in the tangle of new friendships that followed, found himself needing a vehicle he didn't want registered in his own name, the result of an awkward deposition he'd given in a friend's divorce case. Goodman agreed to let the truck sit in her name while Lewis made payments toward owning it outright. It worked for a while. Then Lewis stopped paying for insurance, and the truck, repossessed once already from his mother's house, found its way back to him only after he scraped together enough money to retrieve it. When he moved back to Panama City, the truck mysteriously vanished from outside his house days later. He reported it stolen. The police arrived, and instead of helping him locate it, arrested him. Goodman had filed a police report claiming he'd taken the vehicle without permission. Lewis spent 16 days in jail over the incident, missing an entire week with his children at Christmas. He felt, understandably, wronged, filing his own lawsuit for the damage that false arrest, as he saw it, had done to his life. But the judge, working through the layers of the story, found something far less sympathetic underneath. Lewis hadn't paid Goodman for the insurance that month. He had no insurance policy of his own. He didn't have a valid driver's license either. Suspended over unpaid tickets stemming from a motorcycle accident, tickets for riding without the proper endorsement and for careless driving. And critically, his own roommate had told him explicitly, "Don't take the truck, there's no insurance on it." The judge, who had walked into the case fully prepared to side with Lewis based on the paperwork alone, found her sympathy evaporating in real time as the details emerged. The truck was titled in Goodman's name. If Lewis got into an accident, uninsured, unlicensed, it wouldn't be his bank account or his car on the line. It would be hers. Everything she owned would be exposed to liability for a vehicle she could no longer control once it left her sight without her permission. Case dismissed. Mary Cochran had been moved by Jackie Saylor's story. 18 years old, a baby, working hard, struggling in a cramped apartment with little family support. So Cochran, facing her own divorce, invited Saylor and the baby to move in, hoping the arrangement would help them both. There was no agreement about rent at first. This was meant to be companionship, not a landlord-tenant relationship. Cochran helped Saylor buy a car, charging the full amount to her own credit card, while Saylor made payments toward paying it back. A futon, too, went on the same card. Eventually, feeling guilty about freeloading, Saylor began contributing rent, though she only managed 2 full months before falling behind and eventually moving out, taking the futon with her and leaving an outstanding balance on the car. What the judge zeroed in on wasn't really in dispute. Saylor acknowledged the car debt, acknowledged the rent shortfall, but balked at being responsible for the interest accumulating on Cochran's credit card. She was 18 at the time, she said, and didn't understand how credit worked. The judge wasn't moved by the argument. Credit cards charge interest because that's how the companies make money. Someone has to cover that cost, and it certainly wasn't going to be Cochran, who'd extended the credit as a favor in the first place. Doing the arithmetic, the remaining car balance, the unpaid June rent, the missed July rent entirely, the judge landed on a final figure. Judgment for the plaintiff, $2,073. Few cases tested the judge's patience for excuses, quite like Rodriguez versus Johnson. Timothy Rodriguez, a union carpenter earning around $40,000 a year, had once dated Elizabeth Johnson. During the relationship, Johnson had been behind the wheel of his truck twice, both times in minor accidents that left dents and scrapes, and Rodriguez claimed she'd promised to pay for the repairs. But the deeper story, the one the judge dug toward with visible relish, was about money owed elsewhere. Johnson's mother had loaned Rodriguez $6,000, partly to help him pay down back child support before a judge sent him to jail for failing to pay it. Not for the daughter he shared with Johnson, but for 2 other children from a previous relationship. He'd never repaid a cent of it. The judge picked apart his finances with surgical precision. His rent, his truck payment, his car insurance, his second job paid under the table, his child support obligations across multiple children. The math simply didn't support his claim of poverty. When Rodriguez explained that he couldn't repay the loan because a restraining order prevented him from contacting Johnson's family, the judge dismantled the excuse instantly. Nothing stopped him from mailing a check, and nothing stopped him from bringing that check to court that very day, an opportunity he'd conveniently failed to prepare for. Johnson's own behavior didn't escape scrutiny either. She'd known about Rodriguez's temper, years of restraining orders, domestic violence allegations, and let him move in with her anyway, after knowing him for what amounted to a single date. When the judge asked, with no small amount of disbelief, whether Johnson would invite a virtual stranger to move in with her, even she had to admit it wasn't a good idea. There had been a fight involving thrown objects, holes punched in a wall, slapping, hitting, a black eye for Johnson and scratches for Rodriguez. The judge's verdict on the physical altercation was blunt. Putting your hands on someone first, even just to scratch them, means you forfeit the right to be outraged when the retaliation hurts more than you expected. Her counterclaim was dismissed, but the underlying debts were real and undeniable. Rodriguez owed for the truck repairs, and her mother was owed for the loan. The judge structured her ruling cleverly. Judgment for the truck damage would be held in abeyance, meaning Johnson wouldn't see a cent, until proof arrived that Rodriguez had actually repaid the $6,000 debt to her mother in full. Only once that debt was satisfied would the truck judgment be released. Leslie Cook arrived in court carrying an actual wedding dress and 2 bridesmaids' dresses, hoping apparently to use them as props. The judge waved them away immediately. They had nothing to do with the case, and she found them, frankly, distracting. What the case was actually about was a house, or rather a complicated knot of ownership and rent that had tangled around a relationship now over. Cook and her former fiancé, Moore Jones, had leased a home together, a house that was actually still partly owned by Cook through her divorce settlement. She held a 25% stake, even as her ex-husband's family managed it. Jones had moved in and out repeatedly during their relationship, gone for a week in January, gone again in March, under circumstances both contested. Cook said she'd locked him out after finding him loading his belongings into a truck at a pawn shop, having apparently already decided to leave without telling her. Jones claimed he'd simply gone home one day to find the locks changed and his things outside. The judge's sharpest insight came when she examined the actual ownership structure underlying their living arrangement. Since Cook already owned a quarter of the home, and Jones, by some accounting, owned the same share, there was no clean logic to him paying her rent for a property he co-owned just as much as she did, unless some portion of that money was meant to go toward a future joint purchase, which both parties eventually admitted was the real plan. The arrangement, as written, was simply not a clean lease, and the judge wasn't going to force Jones to subsidize a mortgage on a house he no longer lived in and owned just as much of as Cook did. What remained was the matter of personal property, furniture, photographs, childhood mementos, still sitting in each other's homes, both sides distrustful enough to want a police officer present for the exchange. The judge ordered a date, a window of time, and the dignity of supervised retrieval, and left it there. Erica Calderon had babysat for Cami Moore's daughter for a few months, paid through a state childcare subsidy program, working as many as 18 hours some days. When the payments from the state fell short of covering everything, Calderon claimed Moore had verbally agreed to cover the difference out of pocket, a claim Moore flatly denied, insisting she'd believed the state covered everything dollar for dollar. Layered on top of the babysitting dispute was a used car, an aging Toyota wagon that Calderon sold to Moore for $600, with a $200 down payment and a promise to pay the rest once Moore's tax refund arrived. When the refund came in far smaller than expected and the remaining balance never materialized, Calderon took the car back, keeping the $200 deposit. The judge's read on the situation was almost gleeful in its bluntness. Calderon had effectively gotten her car back, kept the down payment, and even benefited from a new starter Moore had installed during the month she drove it. As for the babysitting money, The judge pointed out that if Calderon had genuinely believed she was owed hundreds of dollars from back in February, she likely would have sued months earlier. The timing suggested this lawsuit was really about the car, dressed up with an old grievance for good measure. Doing the math on the deposit, the starter, and the timeline of everything exchanged, the judge concluded Calderon had already come out ahead by roughly $260. Case dismissed. Gabriel Chavarria, 19, had been doing his laundry at his girlfriend's family home when an argument erupted that would end with accusations flying in both directions. An assault claim from him, a counterclaim from her, and somewhere in the middle, a black eye, a bloody nose belonging to a 4-year-old, and clothes allegedly burned out of spite. The fight had ignited over a phone call. Erica Kick had been on the line with an ex-boyfriend, or perhaps it was simply Chavarria's friend, chatting with the same man, depending on whose account survived contact with the judge's questioning. Chavarria grabbed the phone from Kick's hand. She pulled back. The two struggled, and from there the story split into two competing versions of who hit whom first. By Chavarria's account, Kick struck him near the temple and nose before he struck back in what he called self-defense. By Kick's account, she'd merely pushed him, and he'd responded by punching her squarely in the eye, an injury so severe it left her with a black eye later confirmed by both parties. The judge, working through the conflicting timelines, found something resembling a unifying truth. Somewhere between the two versions lay the reality, and whatever that reality was, both parties had clearly inflicted injuries on each other. But her ruling carried a principle as much as a verdict. Being a woman, she told Kick directly, does not grant immunity from consequences when you choose to put your hands on someone first. If you escalate to violence, and the other person responds with more force than you bargained for, that imbalance, however unfair it feels, falls into the category of too bad. The 4-year-old's bloody nose troubled the judge more than either parent's wounded pride. Whoever struck the door that caught the child's face, neither adult seemed sufficiently focused on the fact that a small child had been hurt in their crossfire. As for the burned clothes, a phone call placed that same evening, captured second-hand through Chavarria's sister, suggested Kick had indeed threatened in anger to destroy his belongings. The judge found this version credible enough to award Chavarria the cost of the clothing he'd had to replace, $453. The counterclaim was dismissed. Ilana Torres, 23, had fallen for Benny de Jesus, a man with one child of his own, a man who had already once faced jail time for unpaid child support, and was now facing it a second time, with 2 years on the line. Desperate to help, Torres had given him money, by her account $2,400, to settle the debt and keep him out of jail. De Jesus didn't deny the money existed, but argued the true amount was smaller, around $1,000, with the rest raised on his own through a piecemeal series of small deposits into a relative's bank account, used because he lacked access to his own. The judge's questioning of de Jesus revealed a man with remarkably little to show for himself. No steady phone, uncertain housing, a track record of falling behind on the one obligation that should have been non-negotiable, supporting his own child. Her verdict on his character was as plain as her math. A man who doesn't pay child support for his own child is, in her words, a bum. A man who does it twice, badly enough to face jail a second time, is a bum twice over. Her sympathy for Torres, meanwhile, was laced with genuine bewilderment. Articulate, employed, raising a child of her own. Why, the judge wondered aloud, would someone like that choose to rescue a man with this particular resume? But bewilderment didn't change the debt. Judgment for the plaintiff, $2,400. Kimberly Johnson and Arthur Spain Jr. shared 2 children and a complicated history that had, by the time it reached the courtroom, expanded to include a third party. Tequila Bailey, the woman Spain moved in with almost immediately after leaving Johnson, and the woman who, within a matter of weeks, became pregnant with his child. The accusations multiplied quickly. Johnson said Bailey had keyed her car, a Pontiac Grand Am, sometime in mid-December, scratching the entire driver's side. She had a witness, a young man who'd overheard Bailey walk in that very night, box cutter in hand, openly admitting to the act and hoping for a confrontation. Separately, Spain had kicked in Johnson's door during a jealous rage, an act that landed him in jail and effectively ended his brief stay with Bailey. Bailey, for her part, denied keying the car and instead painted Spain as the vandal, claiming he'd bragged, the night of his arrest, about both kicking in the door and keying the car himself, a confession allegedly witnessed by Bailey's sister and a friend. The judge sorted through the competing confessions with practiced skepticism, ultimately finding the original police report, filed the same day as the keying incident, more credible than the second-hand recollections offered weeks later. She believed Spain had kicked in the door. She believed Bailey had keyed the car, specifically on the night she'd gone out, supposedly for fast food, and came home instead with a story about scratching up Johnson's vehicle. The math came down to repair costs: $600 for a new paint job. Judgment for the plaintiff. The counterclaim, Bailey's demand that Spain pay her rent for the brief weeks he'd lived with her, got nowhere. There had been no agreement, written or otherwise, and the judge wasn't going to invent one simply because a relationship soured faster than either party expected. As for Bailey's claim that the pregnancy and resulting job loss were somehow Spain's financial responsibility, the judge offered a tart observation rather than a ruling. Anyone who gets pregnant within weeks of taking in a man mid-fight with his ex-girlfriend hasn't necessarily made the wisest decision, and that, unfortunately, isn't a lawsuit the court could hear. Glenn Ford, a barber, had purchased a 1988 Toyota Celica for the daughter of a woman he'd briefly been involved with, Elizabeth Tarrant. When the relationship ended and Tarrant made clear she had no interest in continuing it, Ford suddenly remembered the car wasn't a gift after all. It was, in his retelling, a loan secured by a contract Tarrant had never actually signed. There was also the matter of impound fees. The daughter, lacking a driver's license, had gotten the car impounded. Ford paid to retrieve it, claiming Tarrant had agreed to reimburse him for that cost specifically. The judge's patience for the underlying premise wore thin almost immediately. Ford had the car. He had the title. The relationship that justified any further entanglement with Tarrant was clearly over. Rather than entertain a dispute about sunk costs in a dead relationship, the judge offered Ford blunt, practical advice that doubled as a dismissal. If he believed the car represented real financial losses, the solution was simple: sell it, see what he actually got for it, and only then discover whether there was a real shortfall worth discussing. Coming to court before even attempting that step, she suggested, looked less like seeking justice and more like simply wanting to make trouble. As for the impound fees specifically, those, she conceded, weren't unreasonable to ask back. But the underlying car dispute itself wasn't ready for a verdict until Ford had at least tried to mitigate his own losses. Beatrice Torretta had moved across the country with her husband and infant son to live with a mother she'd barely known growing up, visiting only a few times a year for most of her life. The reunion soured within months. An argument erupted one night involving a drunk brother freshly home from Iraq, shouting matches, and a confrontation that ended with Torretta and her husband moving out that same evening. In an apparent gesture of reconciliation, Torretta's mother had offered her a credit card to cover a week in a hotel while they found permanent housing. Torretta used it for groceries, toiletries, and incidentals. Modest purchases, the kind any family with a newborn might need urgently. But Torretta's mother and her boyfriend later reported the card as stolen, leading to Torretta's arrest. The judge's frustration with the mother's choices was evident and unrestrained. If she didn't want the card used further, the obvious solution was a phone call to the credit card company, cutting off access cleanly and immediately. Not police involvement, not an arrest that would follow a young mother and her infant into a process nearly impossible to undo gracefully. The judge called the decision irrevocably damaging to whatever relationship still existed between mother and daughter, especially given that the charges in question amounted to little more than emergency essentials. Still, the underlying fact remained. Toretta had used a credit card after being warned, explicitly, that further unauthorized use would result in police involvement. Whether or not the warning was wise, it had been given, and crossing that line carried consequences regardless of how reasonable the purchases themselves looked in hindsight. The dispute over personal property, a toy box, a walker, a treasured calendar of photographs Toretta had been compiling since her son's birth, resolved more simply. The mother would return what she still had. The calendar, sadly, was gone for good. A loss the judge acknowledged had no price tag attached to it at all. Marilyn and Thomas Lester had co-signed a car loan for their daughter Nastasia 2 years earlier, watching her make every payment faithfully until an accident on the freeway left the vehicle undrivable. A blown radiator, a swerve to avoid debris in the road. Nastasia left the car at her workplace, hoping a co-worker could help arrange repairs, only for her father to show up, tow it without her knowledge or consent, and bring it home, deciding unilaterally that he would handle getting it fixed. What followed was less a financial dispute than a portrait of family communication breaking down entirely. Natasha, by her own admission, had let the car insurance lapse, a real mistake she didn't try to hide. But that admission didn't give her parents license to simply seize the vehicle without so much as a conversation about next steps. The judge's ruling carried an unmistakable note of disappointment, the tone of someone watching a family fail each other in a small, preventable way. The parents had breached whatever understanding existed by towing the car without permission or discussion. They now had the car in their garage, still undriven, still unrepaired, months after taking it. The judge's instructions were less a legal remedy than a piece of overdue parental advice. Fix the car, sell it, and figure out, separately from this courtroom, what's actually going on between you and your daughter. Case dismissed. Justin Sherman and Jonathan Schiller had once been friends, the kind of friendship built on parties and shared bad decisions, until one drunken evening a month earlier, when Sherman had gotten sick on Schiller's carpet and refused to take responsibility for cleaning it up. The resentment simmered until a high school party, 50-some teenagers, no parents in sight, the kind of gathering the judge found almost comically predictable, where Sherman ran into Schiller and his friends again. By Sherman's account, the night ended with Schiller's group chasing his car down the road afterward, tapping his bumper, shouting threats, and ultimately ramming into the back of his car as he stood on his own front porch. Schiller didn't deny going to Sherman's house that night, honking, trying to provoke a confrontation. He simply denied actually striking the car, insisting any appearance of contact was just the angle of his parked vehicle in the driveway. The judge's read on both young men was almost weary in its familiarity. 2 more examples of what happens when drinking replaces judgment. She noted, with no small amount of irony, that Schiller had apparently believed the ideal moment to talk things out with Sherman was immediately after a case of beer, hardly the conditions for a rational conversation, and exactly the kind of decision-making that turns minor disputes into property damage. The car itself, a 1991 Buick that had belonged to Sherman's great-grandfather, carried sentimental value Sherman desperately wanted recognized. The judge, unmoved by sentiment when it came to dollar figures, pointed out that a $2,000 repair estimate was wildly disproportionate to what a competent body shop would actually charge, likely closer to $500. Judgment for the plaintiff, $500, alongside a pointed warning to both young men that continuing to drink and act recklessly would, sooner or later, cost them something far more permanent than a bumper. Lola Davis loved her granddaughter, a love complicated almost entirely by her own son, currently incarcerated for violating probation tied to a DWI charge, and by Michelle Seco, the child's mother, who had grown suspicious that the Davis family, with money and motive, might try to take the little girl away entirely. Seco had filed for a protective order against Davis and her husband in January, citing a pattern of harassment, repeated calls to family services, repeated calls to police, checking on the child's well-being, constant pressure whenever Seco limited their access to her daughter. The petition also referenced a comment from Davis's son about moving to Kansas City for work and potentially seeking custody. a comment Seiko had spun in her own mind into a fear that the Davis family might attempt to kidnap her daughter outright. The judge examined the actual language of the petition with the precision of someone who had read 1,000 such filings and recognized immediately what was missing. Actual facts supporting genuine fear. A petition citing vague worries about money and custody intentions, however unsettling they felt to Seiko, simply didn't rise to the legal threshold required for a protective order. There was no claim of threats, no specific incident suggesting actual danger, just generalized anxiety dressed up as imminent risk. When the case eventually reached a full hearing, it had been dismissed for exactly that reason. Davis now wanted to recover her legal fees from the ordeal, but the judge redirected her frustration toward the more useful target. Not Seiko, who wasn't a lawyer and hadn't deceived anyone, but whichever judge had granted the temporary order in the first place without examining the petition's actual substance. What mattered more in the end was the relationship itself. A grandmother, now cut off from a granddaughter she clearly adored. The judge gently pushed both women toward reconciliation, suggesting a supervised visit, an hour on a Sunday, something small enough to rebuild trust without forcing anyone to relitigate the past. Seiko, visibly softened by the suggestion, agreed to consider it. The lawsuit itself yielded no monetary judgment, but perhaps, the judge seemed to hope, something more valuable than money had been salvaged in its place.